to a 12:15 meeting. I was going to grab this right quick.
Oh, yeah, please do. Sorry, I got.
Okay. Okay, I think so.
I always want to hear,
Appreciate it. Thanks, bud.
Hanging in there.
I figure that's the easiest way to do this.
That's
Okay.
right. Thank you, guys. This has been crazy.
I think it's 12:15, so before we get started, I guess, would you call the roll?
Representative Wadsworth,
Here,
Representative Drummond, Representative Green, here, Representative Ross.
at our last meeting, what we did is, both, the DHR attorneys, and also, Representative, Pascal had amendments, but, DHR did not provide any amendments or substitute. They said they were working on a substitute. Representative Pascal had two amendments. And what we asked them to do is to incorporate it into like a substitute bill.
That's right.
And Representative Pascal has done that, and I believe has provided everybody with a copy of it. Is that correct?
Oh, that's correct.
Yeah. And then, but as far as the, DHR, they have not provided a substitute. And I met with them today and I asked them, do they have one? They said they do have one, but they're not limited to provide that substitute. So I don't have a clue what their substitute is. So, and what they're even proposing. They said they had to go through this. They had told me they was going to get it to me last week, but they had not. And but we met with them today and they still don't have that. So what we have is Representative Pascal's substitute bill, and I'm gonna let him explain what was incorporated and the changes that were made.
Okay. Well, Mr. Chairman, thank you. Committee members, thank y'all for being here. I just want to kind of highlight, yes, everything I do is in good faith. You know, I think that's integrity is something that our society is lacking. And so through this entire process, I will continue to maintain dialogue with all interested parties, stakeholders. In fact, from our public hearing, I made a commitment to Madam Chair that I will continue the dialogue and have done that with every stakeholder that testified against the bill. And I challenged them, asked them to send me in writing any suggested changes, improvements. To this day, I haven't received anything. Just kind of echo what the chairman was saying. You know, DHR, you have information, send it to me. But moving forward from last week, in your document, this substitute bill, I went and highlighted the main areas. Everything that's highlighted is all the information that I went over during our committee meeting, with the exception of two things.
Okay.
And but I'll just kind of briefly walk through each page that's highlighted. I know Representative Ross is not here.
Can I ask you to do this first?
Yes.
You said there were two things that were not in what we had talked about last time. What are
Yes.
those two things first?
everything in here is incorporating what we talked about, except for those two things.
Yes, and it was two things that's outstanding that, that we addressed, that was a concern. And it was dealing with the right of parents to withhold consent. It was dealing with withhold consent from the investigator entering their home and interview the child. The problem was interview the child. So we actually went and put language to address that. I forgot what happened. Okay, it starts on the bottom of page 7. Yes. And so I'll start with line 192. It states that he or she has the right to withhold consent to all of the following. And so going on page 185, it states allowing an investigator from the department to enter his or her home. And the previous version also included or interview the child. So the problem was interview the child. So we took out the interview the child on that line and just still left it with his or her home unless there's a court order or, and here's what the legal experts on the team that I'm working with from at the state level and national level, incident circumstances, that's long-standing case law, Supreme Court rulings, both law enforcement and child protective services. If the child is in harm or they feel the child is in danger, this is the term that the legal community is familiar with. This is, and so.
So let me ask this, on page 7, what originally it had, you could not, they had the right to hold consent. And then one of the exceptions was that they had to have a court order in the home, which I think has been the policy of DHR, that they can't enter a home without a court order. And then the second one is this what you made the change on?
Yes, on line 198, start on line 188.
And allowing an investigator from the department to interview the child unless a court order or the parent or legal guardian is the individual alleged to have committed the abuse or neglect and in circumstances exist. Is that the change that you
Yes,
made?
yes, page line 201, 202 was the main thing that I heard from, I think also DHR was saying, this way, if the parent, if they are being alleged the abuser, that should be the trigger for them to not be able to withhold consent. So that's what line 198 to line 203. That's the only change. We did not have this language in the last week. What we had last week was the parents may withhold consent from entering the home and interview the child. So interview the child, we removed that and made a separate insert stating that the parents still may withhold consent from allowing an investigator from the department to interview his or her child. There's exceptions, 2 exceptions. If there's a court order, and then the second exception is if the parent or legal custodian is the individual alleged to have committed the abuse, and also must be mitigating circumstances along that. Okay, so that's for
Questions?
Yeah.
And I think this is a part that the opposition has a point on. What if the individual that's being investigated is like a brother-in-law, and parents could have a reason to not, to protect them, to try to keep everything, inside the family, so to speak. But this would then prevent, so say it was a brother-in-law, which is uncle, that was being investigated. So according to this, the parents would have the legal right to say you cannot interview my child. Is that correct?
well, with the current language, that is correct, and then we still have a trigger in case the Department of Human Resource feel there's a need. There's a pathway here is the court order.
Okay, let me ask this, if you, 201 and put, allow the investigator to interview, they can investigate and interview the child unless there's court order, or the other thing, if a parent or legal guardian is the individual alleged to have committed. If you did the parent, legal guardian, or a family member is the individual alleged to have been, to have committed the abuse or neglect, would that?
I would say, excuse me,
Go ahead.
I understand, what if it's a boyfriend or neighbor? Somebody else they're trying to protect, they're trying to keep it.
Well, I think this is, once again, with the current practices, I wish it was here, because the current
Sure.
practice allow, this is within their parameters, the current, administrative rule procedures. It's just codify what their current practice is. And the court order allows that. One example, I was talking to a family law attorney over the weekend, they gave an example of almost like what you mentioned, and they said the parents want to be involved in those situations. You know, sometimes you will try to protect the family member, which is an unfortunate situation, but still DHR have a pathway to intervene through a court order. But the average parent, are good parents, and they want DHR to interview the child, but they want to be part of the process. You know? But I think the key thing was the court order. But going back to what you're saying is widen it out, put a comma there, and add any family member.
I think Ms. Ross has a point of, if, we don't want the parent to stop a investigation, maybe if it's a boyfriend of somebody, and, or somebody who's got maybe a relation. I don't know what the proper term would be.
Well, I think going back with the legal language term here on at the end of line 202 and then 203, that is broad. I looked at several cases law. I can't go back and do a one page, have my legal team do a one page legal analysis. That is pretty broad in accepted practice. They'll be talking mitigating circumstance that will capture what we're talking about, you know. But that says there'll be there'll be a conjunction. So I guess maybe on line 200, but there is a court order or include the indigent circumstances up there also, and that will capture everything.
Do they define, is it defined what circumstances?
Well, yeah, there's a long case law, because I get a one page legal analysis, but it allows even law enforcement, you know, we got the Constitution say you cannot, you have to have a search warrant. Well, under this here, there's always exceptions.
That's a term the Supreme Court has used, you know, for, you know, going into somebody's home, you know, under any circumstance. But you're right, it needs to be defined still.
Yeah. Well, I could do a one page. I don't know about defining the bill, because if the DHR legal team was here, I'm pretty sure they'd be able to tell you exactly what they is called it. That's why.
Talk to me about how you're saying that this is kind of their practice now. This is their policy. What you're stating here is, as amended in the yellow, are you saying that that's their policy, how they operate now, that they're going to go interview a boyfriend, you know, say, or girlfriend living in the house, I guess we're talking about interviewing the child, though, right?
Well, the current policy.
Let me rephrase it, because the accused is, you know, the triggering this part. So say it was a boyfriend or somebody who was living in the house, and the parent or guardian is the one being investigated. We're now saying, you're saying that if the parents say, no, you can't interview them right now, they're gonna refuse the interview and then go get a court order. I mean, they wouldn't do that now, would they?
Well, the current policy, they will interview everyone that's in the household. Their current policy, they interview the child absent of the parents or legal custodian. That's the current policy.
The parent, comma, legal guardian, comma, family member, or any person that has lived in the last, say, 12 months in the house.
Inhabiting, or maybe that's a term, or?
If they've lived in the house within 12 months, because all they gotta do is move them out, and then they can deny it. denied.
Well, let's go back to line 200. I think that's so powerful right there. Court order. Do we-
Like, I know DHR is not wanting to go to court, so, they're not wanting to do that. But if you could, to me, I'm just throwing this out, if you could broaden up who they can, this exception, because I know the parent, the living guardian, family member, by blood or marriage, or, anyone who's lived in the household within a period of time, that probably will open it up where they can pretty much interview a lot of anybody that would be connected with this.
What if, and I'm just, you know, I'm thinking about the child and my background working with children. What if it's the person that visits and brings mama drugs? You know, that's her habit and that's her person. And you know, your mind gets all mixed up, even though they're not living in the house, they're in and out. I just, yeah.
Well, this is, once again, the current policy, we're talking about the child. And if the Children Advocacy Center, for example, there is mitigating circumstance, the current policy is, DHR take the child, interview the child away from the parents or anyone, and they would take the child to the Children's Advocacy Center. And once again, this doesn't stop that. This doesn't stop.
So that would fall under extenuating circumstances.
Well, yes.
So they would have that option to define what extenuating circumstances.
Well, it's already defined in
Already.
there, but it's pretty broad and to the point where if DHR feel that a child is in immediate harm or danger, this is off the table. This is
My understanding of the term is basically falls into two different things. You know, police wanna go into your home.
Mhm.
Exigent circumstances would be one, they believe you're destroying evidence right there,
Mhm.
or the other is the safety of somebody. But other than that, I don't think there's any other, and so we're kind of broadening.
Or if the child is in a safety plan situation, that person who has the safety plan could consent.
I'm just saying that we are broadening the term as exigent circumstances. And I don't,
Well, but in here, it refers to, I've not even used that word before.
exigent.
And
They
reason-
talk about that and extenuating. Both of those words are in.
Extenuating,
Yeah.
okay, well, that's,
Yeah, both.
okay.
So,
And the reason we use that word extinction, that we use that word, once again, talk about this constitution mind
I
people throughout
understand
the
that, yeah.
country. They said this is a term, you don't have to define, it's always a long-standing. And going back, another example is if DHR knock on somebody's door and the parents say, okay, I'm not gonna let you in my house, and they hear the child hollering and screaming, guess what? This is off the table. It falls within that premise, you know.
Now, they define in circumstances as three different things, basically. Preventing an imminent danger to life or safety, preventing the destruction or removal of evidence, and hot pursuit of legal suspect.
That's right, yeah. So how would the fact that one of the accused is a brother or the drug dealer be considered part of those three?
I think it's going to end up being parent, legal guardian, family member, person who has the safety plan, and someone who's lived in the household for a period of time.
The DHR current policy, once again, they're good policies, you know, so we don't wanna start revamping the policy. This is just simply say, okay, here's the parameters to inform parents of their due process rights. And then based on the conversation over the last several weeks, people had several questions, you know, let's clarify some language, but their policies allow them, once again, if there's an allegation of child abuse or neglect, the current policies allow them to interview everyone, whether you brother, sister, if you live in that household, the current policy allows them to interview everyone.
What is Texas do?
Okay, well, Texas is even stronger, their language. As a matter of fact, this is, you have a letter
Yeah, I
from
read the letter.
and, I've been talking to their chief of staff there, and their policies even stricter. Well, I need to send you a copy of that, but there's one. Well, theirs is, for as a home, it states the same thing. It says you cannot enter, refuse, allow the way it's called, Department of Family and Protective Services staff to enter the home or interview the child without a court order. That's what theirs are. And so that's what we had in ours. But last week,
That's actually still in there, because that's 6A,
Well,
under page 7.
well, we took the word interview the child out of that sentence. And then,
What line is that?
But under your substitute amendment, that's been taken out, so it's under 6A, it just allows the investigator from the department to enter the home unless there's a court order or, exigent circumstances.
right,
But then you skip down to B, that gets in allow investigator to interview the child outside the home.
right, but on line 196, on the bottom of page 7, you had enter his or her home or interview the child. But because of last week, the conversation we had, we took out interview the child from that line and put it separate, because the way that was written, it was saying the parent had the ability to withhold consent, interview the child at all times. So we did not want that, to including the school or daycare. We'll make sure DHR still have the authority to go to the school or
But under
daycare.
now, after that amendment that you did, entering the home requires court order or consent or exigent circumstances.
Right, one example, if they hear the child scream, whatever, this allows them to go in.
And now, if it's not in the home, then an investigator can interview the child with a court order, or, if the parent, legal guardian, is alleged to have committed that, or exigent circumstances, we're talking about adding family members,
Residing inside the house or something like that.
And I think that would capture all this others. We can say, if it's not directly the parent or legal custodian, and, we're saying, I think they capture everybody else along the court
What
order.
does Texas say for interviewing a child outside the home?
Well, it don't say, yes, theirs is pretty strict, not strong. Yeah, it said refuse to allow. You can refuse to allow the Child Protective Service staff to enter the home or interview the child without a court order, period.
So in that
They're
case,
just saying in Texas, you have to have a court order, period.
so in that case, if a child is in daycare, and the allegations, they've been abused in the daycare, in order to interview that child in Texas, they have to get permission from the parents, period. Or get a court order.
Get a court order, but still, they have that mitigating circumstances. If they feel the child's in immediate danger, that this doesn't override
So that's
that.
a good point. They thought the child was gonna go back to that school and get injured,
Right.
that would be it.
And the same thing I had my original bill written, same thing, but because of concerns, okay, let's just clarify some language there. So even though what you asked about Texas doesn't specify it in there, but still, they have some strong policies too, that this is your due process notifying parents that they can withhold consent from Child Protective Service entering the home and interviewing the child unless you have a court order, period. But you got those mitigating circumstances. You always have an exception. It's a child in harm or danger. It's not written to specify that. But because of the question we had at our table, we just want to elaborate that. We really didn't have to elaborate, but I thought it was an appropriate thing to do because people had concerns.
Yeah, I will say this, I just looked this up, It says, in Texas, Child Protective Services may interview a child during an investigation of alleged child abuse or neglect. The interview may be conducted at any reasonable time and place to the child's home or school. In most cases, Child Protective Service must obtain parental consent before you interview the child. When the parent is present, however, if the parent is not present, the interview may proceed without their consent. Is that?
Now, I wonder if that's, because they just passed this in 2003. But going back to everything's highlighted, those are two questions. We said separate what Texas has, separate the home, withhold consent from entering the home, and separate that from interview the child. So that's why that's what we have here. Separate those two because once again, we want to make sure the safety of the child is first and foremost, but at the same time, we'll have to balance as far as protecting undue wanted entry, intrusion by the government. So that's what this does. So I think this protect the child, and it doesn't alleviate from DHR current policies. In fact, what it does is make it a little more consistent.
I'm gonna tell you what I think. I think on page 8, where it says in 201, where it says investigator department can interview a child unless it's court, can't interview a child unless it's court order or the parent or legal guardian is the individual related to community abuse or neglect and extra circumstances exist. I think you've got to expand. I think you don't have to, but I'm saying, I think it would be helpful if they expanded the circumstances under when DHR can interview somebody without parental consent and without a court order, maybe a family member or alleged or some of the, some of the items that y'all talked about, and then let that be incorporated within the substitute, and then once that's done, I think all we can do today is just agree to submit that to the chairman for her consideration, and then she would then probably. I don't think she's not gonna do anything this week. If I talk to Jenny, and so that way she would have it in time in order to make a decision whether to put it on next week's docket, and then everybody could then study it and then make a decision at the hearing.
What about, and then we gotta go on the second point, there's another area that we didn't cover last week that you're gonna tell us about too.
Well, no, those are two. Was entering home, entering home and child.
So two within that same time.
Yeah. So we separate.
It's DHR's speaking point. The issue of whether they have to have a court order, and when it comes down to it, is from pages 7, 192 through 203 on page 8. Is that really the sticking point that DHR has in objecting to the bill, or are there other things?
Well, I think these are objecting to the entire concept of any type of transparency oversight. I think these are objecting to it, period.
Okay.
But going back to what I mentioned earlier in my opening remarks is, I'm trying to address this issue in good faith,
And then well, I don't know what conversation you had in last week, but that my understanding was both sides were gonna, they were gonna send you something of a sub, and then,
But they had indicated they were going to give me a copy of it,
Right.
and they had not. They indicated they had it drafted, but then they wanted to get the Sheriff Association, the DA Association on board, and at this point, I don't think that's been done, and so and then I requested, they said they had it drafted, but they can't release it until, so that, I don't have.
Until when? We don't know why? Oh, okay.
Well, I made a note here based on, I will look at reference. I have my team look reference along the LSA, look at language to expand that in accordance with their current policy, you know. But, you know, y'all the committee members, this is my bill and bring it to you, but I want to highlight, I'm trying to do my part in good faith. And I don't think anyone that's not trying to do things in good faith should be rewarded
I think,
either, you know.
I think you have brought, the amendments, like I said.
You have really, I have to say, you have really worked on this. I mean, you've done a lot of research. You've talked to a lot of people,
And you
and I
actually,
commend you.
and you actually educated me.
Yes.
Oh, yeah, absolutely.
And I understand the bill.
So do we have to take a vote on anything, or?
We don't have I think the only thing we want to do is just, agree to have him make those amendments and then submit it to Jenny for her consideration. And, but as far as actual voting on the bill, I think we have to wait, we need to wait till, those changes are made. And then, we'll have this at whatever committee meeting.
Yeah, I'm gonna
That she
do
said.
that, so with those changes.
And so for clarity here, hope you can say that out loud. Okay, is tweak line 201 and 203.
I'll do this,
Fine tune.
yeah, 198, 193, because you've already tweaked 7, 195 and 96.
Right, okay.
You know, I don't know if you need to define what the term, those 3, points in there about, pose of danger, that we looked at, and define what exit circumstances actually means. You know, that'd be helpful, for just clarification, which that's gonna cover, if you have a danger to the child, you have, loss of evidence, and also,
Pursuit.
yeah,
Yeah.
I
that one,
think that's
Paul.
pretty much gonna cover most.
Do you want him to define it in the bill?
Cause they do
Yes.
leave, if they know you're investigating, one day the child's at school, the next day they're gone, we don't know
Yeah,
where.
and I think, maybe the committee can vote to at least, does the committee want those in the bill? What the definition of extra circumstances is, or do you think just leave it wide open so that they can see?
There was exigent circumstances and one other term we had discussed too. What was that other term? Extenuating. And, I'm kind of neutral. I mean, if, Tim, you're the attorney.
Yeah, I'm neutral.
Do you think it needs to be defined because those are long-standing definitions in the legal field, so.
I think if you define them, you may limit them.
That's right.
And,
So I would say not define them.
and I want to commend you for working as hard as you have on this. I think you've done a really, really good job doing that. And just have the substitute, so she can, Jenny can then submit it out to everybody. Submit it out to everybody.
Right, okay. Okay, all right, well, definitely
And
appreciate it.
was there any other thing that they were opposed to that you could recall?
Well, no, that's how I recall it. Everything else was in the amendment that we had last week, and the only thing going through the amendment was the outstanding was those 2 areas. Because, you know, they just want to make sure that they still could go to the school or daycare, you know, in case talk to the child. You know.
I appreciate it. Did y'all have any other questions? I guess we're adjourned. Thank you.
Good job.
See,